Hi everyone, this is Sean. In today's video, I'm going to be answering a question that was posed, and that question is from one of you guys, one of our subscribers. Our subscriber is a private security officer, works armed, and realizes that some of his or her coworkers might have some questions as to what the legal ramifications are for presenting a firearm on your personal property, even off of your property. So let's dwell into that. But before we get started, as you guys know, I am not an attorney. Nothing in this video shall be construed to be legal advice, should not be construed to be professional advice. Don't take this as professional training. With training, you have to have somebody that's qualified, other than me, present the topic to you and answer any questions that you have. I will answer some questions, but remember, this is not training. This is a briefing topic. This is a topic that you can bring to your team, discuss a little bit further. I also do not represent any law enforcement agency. I don't represent any government agency as well, or any employer. So let's get started. Many of you are armed, you're armed security, and you have your personal firearm. You're not issued a firearm. Some of you might be, and you're able to take it home. But many of you bring a firearm to your house, and you might wonder what you could do with it. Well, let me tell you this from the get-go. Every state's going to differ. I'm in California. I tend to gravitate towards California law. But remember, most of the states are modeled after the MPC. That's the Model Penal Code. So even the laws in California might actually run, not even contrary, runs very similar to the laws in your state. When you're a private security officer, you're probably securing your firearm at home, and you're always wondering, you might have a scenario, what happens if somebody breaks into my car? What happens if somebody breaks into my truck? What can I do? So let's discuss that. So if the vehicle's parked on your property, if you pull out your firearm and you approach this person, here's the legal ramifications. Because a firearm is a deadly weapon that's likely to result in great bodily injury or death, you need to be justified for drawing that weapon and pointing that muzzle at a human being. What is justification? Well, what justifications do you need? Well, number one, you have to prove that reasonable fear to your life or the life of somebody else. You have to prove that there's an imminent danger. There's an imminent danger to harm to yourself or somebody else. Okay? And you have to also show that this person who you're approaching might have a weapon or have some type of instrument that is likely to cause great bodily injury or death to yourself. That is the justification that we need, because the firearm is a weapon that's likely to result in great bodily injury. If you have an accidental discharge and it goes off, or even an intentional discharge that goes off, you're going to have a lot of explaining to do. And you want to have those three elements already locked into your statement. Can you approach somebody outside your house that's doing this to you with your firearm? You can, but this is the problem. You don't have backup. You don't have partners that you can call on the radio, and you don't have any less lethal options. There's the Ahmed Arbery trial that just concluded. Defendants are all guilty for murder. They did not have any less lethal options. At the time, all that they had was a shotgun, and that's it. There's no less lethal. When you're confronting somebody outside your house, you probably don't have any less lethal options other than hand-to-hand combat, but that's really it. But could you approach them with a firearm in your hand? You could. But what are you going to do when they come after you with just hands? Are you able to use a firearm with a less lethal threat? Well, your argument is going to have to be that you were in grave fear of being killed or seriously being injured. Proving that is going to be difficult if the person didn't have a weapon with them. Number two, if they're running away, that reasonable fear element, and let's just say they're running away off your property, that reasonable fear element is going to be mitigated. Okay? How in the world are you going to justify reasonable fear if the person is fleeing from you, they're running away from you, and yet you are chasing them, you are in pursuit of them. A scared person doesn't run after somebody, okay, because then you're not scared. Now, number one, if you have a legal duty to do so, that's different. Like police officers, law enforcement officers, they have a legal duty. No, I'm sorry, they don't have a legal duty. They have a public duty. They have a public duty to pursue and arrest this person. Obviously, depending on the type of offense that was committed. For private citizens, is there a legal duty to catch this person that was running away? There's a big question mark on that. Now, you can affect a private person's arrest and you could use reasonable force, but again, the question of reasonable fear is going to be a huge issue if you're running after them, you're chasing them, and you're going away from a place of safety, which is your residence. It's going to be harder to prove. I'm not saying that you can't prove it, but it's going to be a lot more difficult. And you also have to realize that you're going to need to have a crime that's committed, and you're going to have to effect a legal arrest. If you're not effecting a legal arrest and you're just charging at somebody, chasing them down, okay, in a way that's vigilante justice, and that is condemned by a lot of jurors. A lot of jurors don't like the vigilante justice. They prefer you to call the police, even though there's a lot less police out there. This is becoming a dangerous world right now. So as for chasing them, look, if you have insurance, you can always obviously pay the deductible, but there's no deductible to be paid once you're behind bars awaiting trial. And what we've been seeing on the news, just the news, it just seems like a lot of prosecutors on the news are abusing their prosecutorial discretion and charging whom they want based on the political push at the time, which is wrong. It's wrong, but we still don't want to be in that predicament, even though we think we're right. In the Ahmaud Arbery trial, the huge question mark is what kind of crime were they trying to affect a private person's arrest on? And there's a bunch of huge question marks. Was it burglary? Well, that's a big question mark for that one. Okay, you have a house that's being renovated. It's unknown if he took something at that time. And perhaps in other states, in order for you to present deadly force or use deadly force, you might need a felony crime. In the end of everything, if you didn't have a crime, you might not have justification. I think that's what happened at the Arbery trial is the defendants were not able to prove that they have reasonable cause to believe that an actual crime occurred. And that's how a self-defense incident, an alleged self-defense incident, turned into homicide. So you gotta be really, really, really careful. Try to avoid the vigilante way. Now, if this person comes inside of your house, that reasonable fear element I was telling you about, it becomes more of a reality because the chances are this: if the light is on in the house, the intruder knows that somebody's home, yet they're trying to come in. They know that they're going to be met with violence, and in a lot of cases, they don't hesitate to bring a gun in this home invasion. And if you end up using deadly force or force that can cause serious bodily injury, like using a gun on somebody in your house, you're going to be able to show that reasonable fear a lot more better than if you're outside of your residence. Okay. In California, we actually have a penal code that says, and believe this or not, this is California, you guys, one of the most liberal states. In California, there's a penal code. It's between the code for 192 and 187. It's somewhere in that category, and it talks about when you're inside of your residence, an intruder comes in. If you can prove, or you have evidence or reasonable cause to believe that the intruder is actually forcing entry inside your residence, okay, it actually says that the reasonable force element can be substituted by you having reasonable cause that the intruder came in forcefully. Okay, let me say that again. In California, if you can prove that you reasonably believe that there was a current burglary occurring, intruders coming in your house using forced entry, you can use deadly force. And if there is if there is a reasonable fear element, which there is, the breaking and entering into the residence substitute that reasonable fear. Now, you're still going to have to prove some other things. You're going to have to prove that this person was an imminent threat to you or your family or other people. Okay, that something was about to happen. And you're also going to have to prove that this person had the means and capability of presenting deadly force to you, or maybe they did already. Okay, there's so much to argue. You can't just shoot somebody in your house if they come in and just depend on the penal code. There's a lot more that comes with it, but at least you'll have a foundation of defense. That's all I have. What do the laws in your guys' state mention? What is your opinion on producing your weapon on your property to prevent maybe a property crime? What's your thoughts about pursuing somebody off of your property and trying to effect a private person's arrest? Do you do it? Do you not? Does it depend on the type of crime? And if it does depend on the type of crime, well, what crime would, in your opinion, would justify you to chase them off the property? Okay. One last thought is, when you chase this person off the property, you don't know if other people are going to be waiting for him or even her. When there's a passerby that might be a concealed weapon carrier and they see you pointing a firearm at somebody, they might think that you're the bad guy. Same thing with the police. They might think that you're the bad guy. Your heart's going to be beating 150 to 170 beats per minute, maybe even slower depending on your level of fitness. And you're not going to get to think clearly. You're not going to have that peripheral vision where you're able to see around you, see on both sides. You may not hear somebody telling you, the good guy, to put the gun down, because there's something called auditory exclusion, which I will argue with some of these psychologists out there that try to debunk that myth. It's true. In times of stress, extreme stress, you have tunnel vision, you focus on the threat, and you might have auditory exclusion. That's my argument. Even with gunfire, you end up having to use lethal force, or your partner, you might not even hear the gunfire, or it might sound like little pops. Let me know what you guys' thoughts are. Take care.